The exclusionary rule is the remedy when the Fourth, Fifth, or Sixth Amendment is violated. We've got clear case law that applies it to the Fourth. We think it applies to the Fifth and Sixth, although those arguments are not as strong. So where does this exclusionary rule power really come from? Well, if I think about the due process guarantee against coerced confessions, the due process clause guarantee against unreasonably suggestive identification procedures, that Sixth Amendment right to counsel, that Sixth Amendment right to guarantee representation, I can see a need for the exclusionary rule for the Fifth and the Sixth Amendment. And we all remember attenuation of the taint, right? Where we had the unlawful arrest of Toy, the lawful arrest of Han Wei, maybe, maybe not, the unlawful arrest of Yi, the unlawful arrest of Wang Sung. Heroin is misspelled up there, I think. We have inculpatory statements, and we have inculpatory statements. Maybe heroin was not misspelled. Does it have an E on the end of it? I don't think so.
Yeah, that's a female.
That's like a female. That's why spell check didn't catch it, because they had a female hero who was running around maybe doing a LRP or something, right? LARP, I'm sorry. Yeah, I was thinking Long Range Reconnaissance Patrol, but it's actually live action role play, LARP as opposed to LRP. And I'm not going to tell you where I learned about LARPs. Good faith, we've talked about earlier, right? Limitations on good faith. If the cop misleads the magistrate, if the magistrate is a rubber stamp, or if it would be unreasonable for the cops to rely on the warrant's probable cause basis because the police officers know that the information in the warrant is not valid, or if the warrant on his face is just so bad. If I've got those sets of circumstances, then I'm not going to allow that. Let's see here. No, I have not. I haven't posted either one of these. It's not going to help you any. It won't matter, but let's see. Yeah, I want to go up here. I was going through the slides and looking at them, thinking about the exclusionary rule last night. And I thought that I would remind you of a couple of cases. Alderman v. U.S. introduced the concept of standing. I had a question in class yesterday. Professor Rose, should I address standing at the beginning of my analysis or at the point in the analysis where I have to decide whether or not the exclusionary rule applies? And my answer is you apply standing where it makes the most sense. Sometimes it may be in one place and sometimes it may be in another. Now, the problem with standing is it narrows when the exclusionary rule does or does not apply. So if it narrows when the exclusionary rule does or does not apply, it may be that talking about standing when I talk about the exclusionary rule to some degree is a necessary component of my analysis. And you remember Racus, this was a big deal. And I want to remind you, in Racus, those guys were entitled to be in that automobile. They had every right to be there. They'd been given permission by the folks who own it. And the doors of the vehicle were closed. And none of that mattered from the standpoint of asserting standing. Why were they not entitled to object? Well, they tied it to legitimate expectation of privacy. Riddle me this, Batman. Does Jones and Jardine create a situation where someone who is entitled to the possession of the vehicle, not because they own it, but because of a bailor-bailee relationship where it's been loaned to them, if they don't have the expectation of privacy, do they nonetheless have a right to not be trespassed against physically? Because Racus does not answer that question. because racus is a reasonable expectation of privacy case. Yes?
Why would you assume that they wouldn't have a reasonable expectation of privacy if they have a key to the car, they have limited access to the car?
The only reason that I would assume it is because the case tells me that they don't have that expectation of privacy if they're in a car that's not theirs. And it tied it to the possession of the car. So,
Does it depend on how long you have possession of the car? If you're borrowing it to go to the store versus not borrowing it for 2 weeks, does it change then?
the argument that I would make, and if I begin my answer with the argument that I would make, is that there is no answer, right? The argument that I would make is that an expectation of privacy was created because of the existence of the lending of the vehicle that created a private relationship between the lendor and the leasee. And I would make the argument that that created both an expectation of privacy and a trespassory interest in that car while they were in possession of it. And therefore they have standing to assert a violation of it. Now, whether or not that argument would be successful, I don't know. But if we're thinking about standing and how standing narrows your ability to assert the application of the exclusionary rule, when Racus was written, it was written through the lens of reasonable expectation of privacy. If I can attack it as a criminal defense lawyer now, one area that I could attack, where I could not attack just 2 years ago, is to take the holdings in Jones and take the holdings in Jardines and begin to look at whether or not, even if I don't have an expectation of privacy in something that has been loaned to me, I do have a trespassory interest in it because I'm currently in possession of it. Ergo kumquat, because of my relationship with the person who loaned it to me, I stand in the shoes of the owner from the trespassory interest perspective. And I'm talking about some very old common law concept of bailor, bailee, which applies in the criminal law when I'm dealing in situations with pawn shops, with embezzlement, with fraud. There's an interesting argument to be made there. There's probably actually an interesting paper to be written there about whether or not you can use trespassory interest to expand the application of the exclusionary rule in Fourth Amendment cases. It's a very interesting thing. If you don't say that on the exam, I don't care. But if you're looking for a topic for an independent research paper to write so that you don't have to sit in a boring seminar class for an entire semester and talk about, the naval and the law, this would be an interesting one to write on. So I think about Racus. Racus immediately raised the question of standing of guests in the home, right? And we read Minnesota v. Carter, and we eventually got ourselves to the social guest conundrum, right? And we know that when I have a home, the host has that reasonable expectation of privacy. A guest has a reasonable expectation of privacy if I can establish a meaningful connection to the area where they want to assert the reasonable expectation of privacy. And the question really is, what is a meaningful connection? And we talked about things like they let you use the room, they give you the guest bedroom, you have your suitcase there. It's a very fact-intensive inquiry, right? And so what I would want you to do is to make that fact-intensive inquiry, and whichever way you come out is fine by me, as long as it's helpful to you. Now, what we didn't talk about, though, is what about standing for Miranda and Messiah and Fifth Amendment due process? Because all of the standing cases that we've read have been Fourth Amendment standing cases. Well, if I go and look at it, the court has not decided any cases on standing in the violation of the other amendments. So if I'm going to port it over, Miranda's pretty easy, because to be the victim of a Miranda violation generally means that you're the suspect in the case. Although potentially you could come up with a fact pattern that would twist it otherwise. Generally speaking, it's not a problem. Messiah-based exclusions probably have that same standing limitation, although I don't know because there's never been a case. But I think you're on relatively firm ground in applying the concepts of standing to Fifth and Sixth Amendment violations. What about coerced confessions? Coerced confessions are the one that I think is different. And why do I think it's different? Because that due process right exists. Those coerced statements are also presumptively unreliable. And we really want to deter the type of police misconduct that results in coerced statements. And if you go and look at the fifth due process and the reason for the Fifth Amendment due process, there's a strong argument to be made that anyone could assert an argument against evidence that came from a coerced confession, even if they did not have standing under racus. Now, this area of the law has not been decided, which means that I'm not going to hold you to it one way or the other. But it's another interesting thought that I wanted to point out to you, sort of as we're at the end of the semester. We talked about the independent source doctrine. Just want to throw the language up for you again. If certain facts are discovered illegally, but knowledge of them is also gained from an independent source, those facts may be proved like any other. And we did the two lines in class, different lines of independent analysis. And that language is right out of Silverthorne Lumber and Murray v. United States. So, independent source, in one way, there's no connection. But in the other way, let's see if I can describe this right. In the first instance, if I find evidence completely separately, the evidence that I find separately is admissible. In the second instance, I can find the evidence illegally, but if I can get to that same evidence independently, I can admit that same evidence. So independent source is potentially broader in scope as an exception to the exclusionary rule, depending upon the way in which we get to the independent source. Anything else I will tell you here? I have to show that the acquisition is independent of the illegality. That makes it different from the other exception doctrines to the exclusionary rule. It is separate and apart from the other actions in the investigation of the case. Attenuation of the taint is not separate and apart from. Inevitable discovery is not separate and apart from. And neither is the good faith exception. And that's the way in which independent source is different. And I talked about that the other day, but I wasn't sure that it stuck clearly. So I wanted to make certain that it was discussed in class today. Let's see. I think that concludes everything that I wanted to talk with you about today. Let me remind you one last time, we're looking at 20 multiple choice questions. The multiple choice questions on the exam are going to be derived primarily from Supreme Court cases with the facts twisted so that they fall under the application of the relevant law and standard, or they don't. Think Serralo, think Open Fields Doctrine. Those sorts of cases are the types of cases that you will see in the multiple choice section. There's a lot of them that I can test that are narrow in scope individually that you also need to know to apply substantively. It's why I included, I'll just remind you, the black letter law at the end of each of these cases. Because if you can identify the standard and you remember the facts of the case, you can see them when they come up again on multiple choice questions on the bar exam, because that's the way it's tested on the multi-state bar. And that's the way that I'll test it. I'll also have 4 or 5 questions that are sort of mini applications, do this or do that, but it'll all be derived from the law. Kyle.
You mentioned a few times it'll be a 6-hour exam and take it 4 hours. Is there reality to that, and then most of us won't finish it, and you design it that way, or is it like some will, some won't, or I'm curious about pacing.
I think pacing is a good question. I would recommend to you, although I do not require, that you do the multiple choice questions first, and you then answer the exam. And if you get done with the exam, you go back and check your multiple choice questions again. I ask enough questions that you don't have time to sort of dilly-dally through the exam. I want to create enough pressure that you can either answer it or you can't. And the reason that I create so much is because it helps sort out who truly knows the subject and who just sort of knows the subject. And all the things that you would expect to need to do on an exam, you need to do here. It's going to be a multi-page fact pattern with multiple incidences as all part of an investigation at multiple locations with multiple people, both defendants and law enforcement, which means you've got to manage all this data. It means the structure that you impose in the management of the data will be important in my ability to understand the argument that you are making. And that's art, folks. Each and every one of you has varying degrees of ability to manage that data. Some of you will like to begin with the law because that's the way your mind works. Some of you will want to begin with the facts and work back to the law. I don't care. I'm looking to see if the argument that you make is legally correct and logically defensible. So I don't have a preferred structure. Issue, rule, analysis, conclusion tends to work most of the time, but you may have something better, and I'm fine with that. But because it is a multi-page fact pattern, because there is a lot of information, there is a tendency on the exam to peter out about 75% of the way through the essay. And so I'll have several essays that are all good, and then it's like someone just says, "Oh, screw it, I can't do it anymore." Literally. And the last page is like, blah, blah, blah. Okay, well, I got it. You saw it. You identified the issue. You didn't have time. You know, if for God's sakes you get to the end and you haven't got the time to write all the answer, if you have outlined the issues that you expect to see, and I see where you were going to go, if you had time to finish, I'm going to give you credit for that. Because I'm looking to see primarily issue spotting and understanding of the substantive law, because that's what the bar tests. Yes? It's one essay. It's one essay question, but the problem, I think, is either 4 or 5 pages in length. The fact pattern's 4 or 5 pages in length. You will recognize it when you see it. Yes?
I'm a transfer, so this might be a stupid question, I don't know.
There are no stupid questions.
Do you give us an allotted, do you allot?
No, I give you, some professors do. I give you the discretion. There'll be a recommendation on the exam for how much time to spend with each, but I have no requirement in that regard, and the proctors are not going to be watching you. I think that's sort of BS. You should manage your test like you manage your life. That being said, a multiple choice question on the bar exam you are expected to answer in 1.8 minutes. In fact, if you don't answer multiple choice questions in 1.8 minutes on the bar exam, you won't answer all the bar exam questions before you get done. I'm giving you 20 questions. In my mind, I think you're probably going to take about 3 minutes per question, which is almost double what the bar gives you. That puts you at 60 minutes, right? I'm giving you another 180 minutes because I want a product that's worth reading. I don't want you to feel so rushed for time that you can't answer it, but you will. Usually, very few people leave the room early when they're taking my test on the criminal procedure exam. Sometimes they do or leave early on the evidence exam because I ask a crap load of multiple choice questions in the evidence exam. because I need to see whether or not you can pass the bar. Because evidence is one of the two hardest subjects on the bar, the other one being property. So I don't have that problem here. Here I'm looking for the lawyer's mind who can analytically apply the law. So if you have problems with multiple choice, as long as you're okay in the curve of the multiple choice, it's not going to push you up or down one way or the other. I usually get the question, Professor Rose, what is the range of correct answers when you give 20 multiple choice questions in this class? And the answer is anywhere between 6 right out of 20 to about 15. Now, in order to pass the bar, you need to get about a 67 to 70% correct ratio. So those of you who get 14 or more right on the multiple choice section of my exam are probably almost ready to pass the Crim Pro section of the bar when you leave this class. That won't be the majority of you. Most of you are going to get somewhere between 9 and 11 multiple choice questions right. That's just historically what has happened. Prove me wrong, I think that'd be great. But historically, that's what's happened. That means that a 50 to 55% correct rate on my multiple choice questions is probably going to be good enough for you to get somewhere between a 2.75 and a 3.0 in this class, as long as you write a competent essay. Now, it might freak some of you out for me to talk about grading in such detail, but I want it to be transparent. I want you to know exactly what I'm looking for. I want you to know exactly what I expect, so that if things go south with you on the exam and you come to talk to me about it, we're not talking about how I didn't tell you something. You will literally recognize the names of the people in the essay question if you've done the discussion problems this semester. And if you haven't and you ask for an exam review, I'll be happy to point them out to you when we sit down to talk about it. Which leads me to sort of the final comment. Just because a discussion problem is written a certain way in our textbook does not mean that it applies the same way on the exam. You must read the facts carefully to see what differences arise. Because I can change one fact in a paragraph and change everything under Fourth Amendment jurisprudence. So it's not like I've given you the exam ahead of time. What I've tried to do this semester is to give you the focus so that you can be successful to the maximum extent possible. What I'm hoping for is that each and every one of you gets better than 10 on the multiple choice and the essays blow me out of the water. That's what I'm hoping for. And I've taught the class differently this time to try to increase your performance. Some of you will, no doubt, make certain that that doesn't happen anyway. And that's okay. We all have bad days, right? We all have bad days. But you really got to work to flunk it. It's possible. I failed one person in 9 years at this law school. One. Don't be number 2. Any other questions? Yes, ma'am.
I couldn't find the definition of open fields in the Sorala case.
It doesn't come from the case itself.
It doesn't? It just,
No.
Okay.
Remember the bullseye that I drew on the board? Reasonable expectation of privacy in the home. Curtilage is right around it. If I get outside the curtilage, I'm in the open fields. And if I'm in the open fields, I don't have an expectation of privacy unless I do something to assert that expectation of privacy, like put my dope in a barn or cover my marijuana with camouflage netting. Then maybe I'm trying. But even then, it's in the open fields. If they can see it, we're okay. We're okay. Any other questions? It's perfectly appropriate that Keely has the last question on the last day of class. All right, guys. You can write me with questions between now and when the exam starts. When we get about 2 or 3 days from the exam, I'm probably just going to tell you to go take a walk around the street and cool off because we're too late at that point. All right? Good luck.